All right, I think we're ready to start. Everybody, welcome to this year's Hyde Park Debate. I want to welcome everybody who's here in the room with us and also everybody who's joining us remotely. We're grateful to have you with us today. And we are pleased to have with us remotely Sara Benson, who's copyright librarian at the University of Illinois, and Kevin Smith, who is Dean of Libraries at the University of Kansas and Director of the University Press of Kansas. My name is Rick Anderson. I'm the University Librarian at Brigham Young University, and I'll be your host and moderator for the debate. And I can see people are already voting. This is exciting. So the resolution before us today is the one that you see on the screen. Resolved, U.S. copyright law no longer meets its fundamental purpose to serve the public good. The program is going to proceed as follows. First, the audience will be polled to determine how many agree with the resolution and how many disagree, and these results will be recorded. Kevin will then make a 10-minute statement in support of the resolution. Sara will then make a 10-minute statement in opposition to it. Kevin will then have 3 minutes in which to respond to Sara's statement, and Sara will have 3 minutes in which to respond to Kevin's. Following the opening statements and the responses, we'll open up the floor to questions and comments from the audience. After the open discussion period, the audience will be polled again, and the results of the second poll will be compared to those of the first. Whichever debater has moved the most votes to his or her side will be declared the winner of the debate. Now, here's an important point, and I'll mention it again later. Because we're measuring the number of votes that move, it's going to be very important that if you want to vote at the end of the debate, you need to make sure that you vote at the beginning. We're going to ask only people who voted at the beginning to vote at the end. As I mentioned, the polling has already begun, but let's ask everybody to please complete your voting, and we'll watch for the numbers to slow down and stop. And at that point, we will close the poll and proceed with the debate. Leah, do we have a way of knowing the number of votes in addition to the percentage? Okay.
Yeah, I'll have it written down for you so we can compare numbers at the end.
Because if only a few votes change, it might not affect the percentage. So, all right, it looks like the numbers are still, while we're waiting for the numbers to settle down, Leah will sing a song for us. Leah?
I've already been required. I made Beth dance on stage earlier today. So.
I could do some Jeopardy, like do 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 do.
I just want to call attention to folks in the chat who are asking to have the poll made available to those who are online. Oh, it just.
Oh, sorry. Yeah, the poll is available to anybody. So if you look at the screen, you can see that you can respond at pollev.com/CHSCONF. And you can also text your vote, and it explains how to do that on the screen too. So anybody who's here, anybody who can see the screen can vote. So since we've just clarified that, we'll maybe give it 1 or 2 more minutes. Just for the information of those who are joining us remotely, it looks like we have about 30 or 40 people in the room here at the Galliard Center in Charleston, and I'm not sure how many we have remotely, but I know that attendance at our earlier sessions has been very robust from remote locations, so it's great to have everybody here. All right, it looks like things have settled down. The relative percentage, let's see, okay, I'm going to give it 30 more seconds, and then we're going to close the poll. This is like watching the voting results last night on CNN, except it's going a little faster. All right, Leah, I think we're ready to close the poll. All right, Leah, and then would you write down the number of votes too when you can? All right, and with that, It looks like 81% of our respondents agree with the resolution and 19% disagree. So we're going to record that result and store it in a secure location until the end of the program. And now we're going to turn the time over to Kevin, who will deliver his 10-minute statement in support of the resolution. And as I have warned our debaters ahead of time, out of fairness to both of them, I'll be enforcing all time limits strictly. Kevin, take it away.
Thank you, Rick. Good morning. As Rick told you, I'm Kevin Smith. I'm the Dean of Libraries at the University of Kansas, and I'm a professor of law at the University of Kansas Law School, and I teach copyright. My role here is to argue in favor of the resolution, which means that I have nowhere really to go but down, so I'm at some risk here, but let's see what I can do. It is something of a commonplace to note that copyright has not always been needed to spur creativity. Shakespeare and Dante didn't need it. Neither did Cervantes, Averroes, or Hildegard of Bingen. Nevertheless, copyright has served later writers pretty well. Charles Dickens and Mark Twain were passionate advocates for the need for strong copyright protection. So I want to start by asking, what changed? Why did the modern regime of statutory monopoly become important for creative production starting in the 17th century? The obvious answer, I think, is technology. Copyright, as we know it, is a child of a particular technological innovation, the printing press. Gutenberg's revolutionary invention clearly had a massive impact on Western culture. It made possible for the first time true mass distribution of literary, scientific, and philosophical works. But it also introduced new economic conditions as well as new costs. Copyright is born out of these conditions. What began as an effort to control the output of this dangerous new technology, boy, doesn't that sound familiar? What began as an effort to control the output of this dangerous new technology rapidly morphed into an effort to rebalance the economic situation for authors and publishers. New audiences were available for all manner of printed work, but there were also new obstacles to reaching that audience, new expenses, and new frictions that characterized the market. Copyright was a brilliant idea about how to realign these technological conditions in ways that would incentivize creativity. And now, copyright law has outlived its usefulness because the environment for creative endeavor has undergone another technological revolution. Now, in the age of digital technologies, where creation is so much less costly and distribution can essentially be free, copyright is no longer relevant. Copyright, as it was born in 1710, has always struggled to incorporate new technologies. The welter of licenses that are now needed to manage the market for music is one example of that poor fit, and photography is another. Figuring out when a photographic reproduction of something is sufficiently creative to warrant copyright protection has bedeviled judges and users ever since Oscar Wilde walked into the studio of Napoleon Cerrone in 1882. Both of these technologies created nearly insurmountable challenges for a copyright regime invented because of movable type, when performance was not an issue and when a copy seemed perfectly clear, or at least what a copy constituted seemed clear. But digital technologies have now entirely confounded the basic principles of copyright, and there is no hope and no point, I will argue, in continually trying to shove the square peg of digital into the round hole of copyright. By their nature, digital networks want to permit access, and efforts to exclude, and exclusion is after all the core principle of copyright, are expensive and they're usually fruitless. DRM and anti-circumvention efforts are a prime example. New digital locks get hacked as fast as you can say DCSS. So that ironically, the movement that was originally intended to create digital locks that would make legal protections irrelevant has now turned to a new legal regime, the anti-circumvention rules added to copyright law by the DMCA, to forbid technological circumvention. This has created a vicious circle that doesn't work, either legally or technologically. Copyright, I suggest, is failing both users and creators. The burgeoning problem of orphan works is an example of how protecting pretty much everything with copyright is causing insurmountable barriers for users with no concomitant reward for creators. Librarians, more than most, understand that copyright in letters that are decades old or in photographs that record our shared history anonymously simply creates an obstacle for users that would otherwise benefit our society as a whole. Fair use is very helpful here, but when we seek to document our history by making entire digital collections available to users around the world, we are asking fair use to do too much. We are trying to use it to overcome the basic flaws of a system of which it is a part itself. On the other side of the coin, the majority of authors and creators, by a huge margin, do not want limited distribution, and they do not plan to make a living from the exclusivity of the copyright market. They want their works to be read, seen, and listened to by as many people as can find them. And when they do seek to monetize their works, it is usually through methods appropriate to the digital media. In this environment, copyright is an unnecessary and unwelcome interference in a burgeoning economy that is built on entirely different principles. The truth is, artists have always struggled to obtain the financial incentive that copyright promises them, especially as massive intermediary corporations, themselves made possible by the copyright regime, have siphoned off those incentives. Money has seldom been the prime motive for a great many creators, even before the internet. Now, in a digital age, millions more people are creators, and they create for a huge variety of reasons and purposes. To choose just one example, music industry attorney Susan Butler noted the massive growth of online music in a presentation for a committee at the World Intellectual Property Organization. Even just as long ago as the days of Napster, Ms. Butler told them, the US recording industry released about 30,000 new songs per year. Now, with the gradual elimination of gatekeepers, about 12 million new songs are released to streaming platforms every year. Millions of people are making their own music, recording it, and releasing it through free or low-cost platforms simply in order to share it with others. So even if copyright worked as advertised, it would work for only a small sliver of these creators. And the technology is stacked against even that dwindling class of people who expect to create traditional media and make a living from it. The problem I noted before about how difficult and expensive it is to exclude people from digital networks continually undermines efforts to exclude those who don't pay. Subscription-based resources, for example, are as expensive as they are because we are paying dearly for the struggle to preserve analog-based exclusion in a digital environment. My most recent copyright class is a good example of the situation we are now in. I had a room full of creators, composers, performers, photographers, and coders, none of whom expected or wanted to use copyright as an incentive for their creativity. Teaching copyright law to that group of students was an exercise in teaching about an historical phenomenon that no longer seemed relevant to their lives as artists and creators. The bottom line is that copyright is failing everyone in the creative ecosphere. It throws up needless obstacles in front of users, and it fails to create the incentives that are workable for the vast majority of the creators for whom it was ostensibly designed. It cannot be saved by tinkering with it in order to update it for digital technology, as the DMCA, for example, tried to do. We need to let go of the basic foundation of copyright law, monopolistic exclusion, in order to think fruitfully about what kinds of incentives and market controls actually make sense in a digital environment. Thank you.
All right, thanks. Thanks so much, Kevin. You came in at under 10 minutes. Well done. And now it's Sarah's turn. Sarah, the floor is yours for your opening statement.
Hello, and thank you for being here today. I think I have the easier job because I'm guessing most of you agreed with the statement, I was right, that US copyright law no longer meets its fundamental purpose to serve the public good. I mean, you've heard of the Copyright Term Extension Act, you've probably heard of Disney, so who wouldn't be against the current version of US copyright law? Not to mention the small claims court that is on the horizon, as well as the myriad copyright troll horror stories. Thus, my job is to convince you the copyright law still does serve its fundamental purpose to serve the public good, specifically by balancing the rights of authors against the opposing rights of the general public, as well as specific groups such as librarians and educators. And who serves the public good more than librarians and educators? Am I right? So I'm up for the challenge. I'm a copyright librarian, a lawbrarian, if you will. I get to engage with US copyright law every single day at my job in the interest of the library, librarians, and my patrons, faculty and staff at the University of Illinois. And as you know, copyright law in the United States goes a long way to help libraries and educational institutions. In fact, we are the envy of much of the world with the amount of exceptions we have built into our copyright law. With the exception maybe of Singapore, where they do have a law that does not allow libraries to waive any of their rights by contract. I do wish our law had that, but barring Singapore, which I'll return to later, we are the envy of the world. While I do agree that copyright law lasts too long, I too am very unhappy about the Copyright Term Extension Act, and I wish copyright law did not last for 70 years after the death of the author. I think the length of copyright is balanced by the many ways that the public can make use of copyright works during the copyright term. How? All of the following exceptions to copyright law are built right into the law. We have Section 107, the fair use limitation on the rights of authors. Section 108, the exceptions and limitations for preservation, copying, and interlibrary loan for libraries and archives. Section 109, the first sale or exhaustion doctrine. Section 110, face-to-face and online teaching exceptions. And Section 504C2, providing limitations on damages for good faith fair use determinations by employees of nonprofit libraries and archives, and more. Let me dive into just a few of these provisions to give you a better idea of why I think US copyright law is still meeting its purpose of serving the public good. Let's begin with Section 108, which provides specific exceptions to copyright law for libraries and archives to make copies of copyright protected works for preservation and for patron use. Although Section 108 is not perfect in that it unnecessarily limits the number of copies librarians can make, and it does not include museums in the provisions, it is also a lifesaver for libraries and archives on a daily basis. If you search in case law to see how many published opinions exist under Section 108, or how many times libraries have been successfully sued in court, you get the satisfying answer that there are still only 2 decisions, and neither found liability for a library or archive for making copies. Not only that, but Section 108 is a model law for other countries, such as those in South America, who have no similar exception to their copyright laws for libraries and archives. One final thing to note about Section 108 is that it explicitly states that nothing in the section prevents libraries or archives from relying on fair use. In other words, where Section 108 ends, fair use begins. As such, some of the flaws of Section 108, such as the limit of making 3 copies for preservation, are cured by the ability to rely on fair use. And since I've already mentioned fair use, let's consider whether fair use is working for libraries and archives. We need look no further than the HathiTrust decision to see that fair use is working for libraries and archives. Libraries are empowered under the HathiTrust decision to make copies of entire books to allow for text searching and access to print for disabled patrons. In fact, in that opinion, the court said, quote, "The creation of a full text searchable database is a quintessentially transformative use," end quote. Libraries like Georgetown University Law Library and my own library have been relying on fair use to also provide controlled digital lending for quite some time. All of this is only further bolstered by the Creative Commons, which utilizes authors' rights through licensing to balance out the public good. Creative Commons licenses permit an author to immediately designate an in-copyright work as part of the public domain, or to permit others to use the work with minimal limitations, such as by attributing the author of the work. And I quote from the Creative Commons here, starting back in 2001, quote, Creative Commons has worked to make intellectual property and copyright laws better serve the public good, drafting full legal licenses that allow authors and creators to share their work with the public and supporting efforts to port these licenses for countries around the world. Creative Commons licenses are not anti-copyright, but rather work with copyright laws to allow creators, quote, to offer certain usage rights to the public while reserving other rights. More importantly, and I bold this quote, without copyright, these tools don't work. So destroy copyright and you destroy fair use, Creative Commons licenses, Section 108 exceptions for libraries and archives, and all of the great balancing tools that are built into the Copyright Act as it currently stands. Why don't we just change copyright law to make it better, you ask? Well, that is one way to better serve the public good. The issue with trying to change the Copyright Act is that recent proposals for change, including the new Small Claims Copyright Court, are not furthering the public good, but instead making the system better for big publishers or copyright trolls. And if you read some of the proposed amendments coming from Senator Tillis, you will see how much he wants to destroy the perfect balance we currently have in the Copyright Act by adding permanent takedown provisions, the DMCA notice and takedown sections, for example. And one need look no farther than the Teach Act provisions in Section 110.2 to see how our legislature can get together to ruin an otherwise good thing. The Teach Act provisions are so difficult to manage and apply that most universities, including my own, would simply prefer to rely on fair use for online teaching materials. I would argue that the thing that is troubling us most today is not the Copyright Act, but rather contract law. Why do I say this? Well, look at the pending legislation on the East Coast, which would require ebook contracts to public libraries to be reasonable in price. What we've lost is the ability to do many of the things that the copyright law provides, such as exercise fair use, engage in interlibrary loan, and more due to terrible licensing agreements. So instead of scrapping copyright law altogether, what we really need is what Singapore already has: no way to breach our exceptions through contract. What we really need is a provision in our copyright law stating that libraries and archives and museums cannot license away our copyright rights, such as fair use. That would go a long way to fixing what is broken, which is not the Copyright Act itself, but rather abusive licensing practices by publishing companies. However, because of legislators like Senator Tillis, as I said earlier, I am very wary of proposing any changes to the Copyright Act at the current moment. Even my senator, Senator Durbin, who's usually quite progressive, wholeheartedly supported the CASE Act establishing a small claims court for copyright liability. In essence, sadly, I do not trust our legislators to modify the Copyright Act in helpful ways at the moment, at least not at the federal level. I do think that state law fights about ebook licensing are moving the conversation in the right direction. And as such, we should likely try to leave the Copyright Act, which has a unique set of exceptions and limitations balancing the rights of authors against the public good alone, at least for now. Thanks.
All right. Thanks very much, Sarah. It's all right. I love rocking out. Kevin, it's now your turn to respond to Sarah. You'll have 3 minutes in which to do so.
Thank you, Rick. I actually don't disagree with anything that Sarah has said, but I do think that with all due respect, she is looking at the problem through a lens that is too narrow. Even if copyright works perfectly for libraries, and Sarah is not saying that at all, it is still failing millions of creators and users. It is true that copyright law was written in a way that favors libraries. That's actually evidence to my mind of how rooted the law is in print technology. The law was written to assist print-based libraries. Some of that still works. But the problems that Sara mentions about contracts, for example, show us how things are breaking down in the digital age. Licensing is filling the gaps created by new technologies that simply don't fit into the categories of copyright law, categories like the doctrine of first sale. And those don't apply to digital works, so we turn to contracts. I also agree that many librarians have done an excellent job of mastering many of the intricacies of copyright so as to reduce the harmful impacts of the law. Indeed, I've spent much of my career working towards exactly that goal. But the point I am making is much broader than the situation for libraries. Let's ask ourselves, why is it necessary for so many librarians to be educated about copyright? The answer is that the law increasingly impacts everyone, not just the commercial author or the professional artist, not just the big publisher or recording artists who can employ experienced lawyers. In a digital age, everyone encounters copyright in their daily lives. And what I've emphasized and what I think Sara has demonstrated is the law is too complicated for those folks to manage. In this environment, turning to libraries and librarians, even highly trained librarians, can only be a stopgap measure. There are too many people running into copyright issues as they write their own fan fiction, record their own music, or publish their own websites. And there are simply not enough librarians to make that situation tenable. In a digital age, we face an onslaught of copyright issues that we try to address with a law that is both ill-suited and excessively complex. The modern copyright statute is often compared to the tax code in its complexity. But in a situation where everyone is expected to know and comply with the law on an almost daily basis, we cannot function with such a complicated statute. We need a law that is less like the tax code and more like the speed limit, easy to understand and to obey. Now, I don't have a clear idea of what such a copyright law would look like, but maybe we should look back at copyright's earliest days, when it comprised a simple right to vend, a right that applies only to commercial efforts to profit from a work. In such an environment, the citizen artist could thrive, and we would still need the reform of licensing that Sara has called for. Thanks.
All right, Kevin, thank you very much for your response. Sara, it's now your turn to respond to Kevin.
Hold on. Can you hear me?
Yeah.
Yes? Okay. Because my Zoom is doing weird things. It doesn't say that you can hear me, but as long as you can, I'm good with that. All right. I admire Kevin's foray into the historical nature of copyright, and I too have struggled to find who owns the copyright of an orphaned work. But I do not think that his arguments about copyright are strong enough to destroy the entire system, which has lasted since, in his own words, the 17th century. And as a side note, often when dealing with an orphan work, I rely on fair use to share the work, as do many of my colleagues engaged in controlled digital lending practices. My response to his points about the supposed failure of copyright to protect both the interests of the authors and the general public is to ask, if not copyright, then what? Would he propose to have simply a world full of licenses? Because, of course, copyright would not be irreplaceable, but rather likely would be replaced by another legal regime, that of contract law. A side note here is to point out that typographical fonts are not copyrightable, but as we all know, are subject to multiple licenses. I applaud the creators and authors who produce creative works with no expectation of remuneration. But I think we can all agree that a world without the TV series Stranger Things would be a sad world indeed. And those particular creators were definitely incentivized by the ability to make a profit. I say this as my 12-year-old daughter was currently shopping for Halloween costumes to look like the character Robin wearing a Scoops Ahoy outfit. As I noted earlier, the world of licensing is already problematic. But take away copyright exceptions and fair use, and it would become disastrous. Publishers would have no incentive to print physical books at all when they could be copied at will without repercussion. When I look into a crystal ball to predict a future with no copyright, what I see is a world full of digital books with restrictive licensing and no print books at all. In addition, digital rights management would become even more stringent because if those protective measures were broken, the publisher or author would own absolutely nothing. So their incentive to share their works with the world would be diminished absent ultra protective DRM measures. In other words, what Kevin sees as utopia looks more to me like a dystopian nightmare. My utopia would be a world where academic journals all flip to open access, librarians are unable to waive copyright exceptions and fair use through contracts, controlled digital lending becomes the norm, and more professors are incentivized through grant programs to create and adopt open educational resources. The more we use the copyright exceptions, fair use, and open access tools we've already got at our disposal, the closer we will come to a balanced copyright system that adequately accounts for the rights of authors as well as the public good. Thank you.
Thanks, Sarah. Perfect timing. Well, thank you to both Kevin and Sarah. Would everybody please join me in thanking them for their excellent statements and responses? And now we turn to the audience. So for the next 15 or 20 minutes, we're going to solicit your thoughts and your questions. Now, this isn't a normal conference presentation at which we would typically insist on questions rather than statements. This is a debate program. So you should feel free to make statements of your own if you wish to contribute to the discourse, or you can pose questions to our debaters. So what we're going to do is, since we don't have a standing mic in the room, if a question comes from the floor here in Charleston, we'll repeat it into a mic here so that our remote users, our remote attendees can hear the question that was asked. And of course, we'll also solicit questions from our remote attendees, which will be fed to us by Leah. And I think we have one already.
Hi, we do have a question from, can you hear me okay? How about now?
No.
This one?
This one's working now.
Great, thank you. I have a question from GW. Kevin, do you have any ideas about how to tackle this legal root problem in the US? Ben Franklin's copyright clause in the Constitution.
Kevin, that question is directed to you. Yep.
Yes, I was muted, as that never happens, right? You try and talk and discover you're on mute. Never happens. I'm not sure I understand the Ben Franklin's copyright clause in the Constitution. I don't know what role Mr. Franklin had in the constitutional clause, which, by the way, does not mandate copyright law or patent law. It doesn't mandate any particular kind of law. It simply empowers Congress to pass such laws if they think they're good ideas. I want to get back to the suggestion that I made that we radically simplify copyright law into a law that protects those who are seeking commercial gain from their works, and begin where copyright law, frankly, did begin, with that kind of approach. And maybe it will be contracts that will fill the gap, but I honestly, Sarah, I think there'll be just as many contracts whichever way we go. So I totally agree with you about the need to reform contract law so that licensing is not as complex and we don't give away rights that the law gives us. But I still think we can simplify and still be true to the vision that the founders had when they authorized the Congress to pass copyright laws. I'm sorry, there is a steam whistle on our campus that goes off when just at the end of when classes are ending, and my office is the closest office on campus to that steam whistle. So that's what you just heard.
I think that was the applause.
I think it was telling me I finished talking.
Do we have, yes, we've got a question from the floor here in Charleston. Go ahead and speak up,
Speak
and then I'll just
loudly.
repeat what you say into the mic.
I'm curious for either of the presenters, how and the copyright law. I know things with every day in our law, but every time there's it, has to be added to understand it. So how do you that
Yeah, great question. So let me paraphrase, and you wave your hand if you think I got it right. So given the fact that case law is constantly accumulating and constantly adding complexity to legislation all the time, what can we do? And Kevin, you've addressed this to some degree, so maybe we start with Sara on the response to this. But what can we do in reality to simplify either existing contract law or copyright law? Sara, why don't we start with you, and then we'll give Kevin a chance to add.
I think that's an excellent question, and copyright law does get a little bit complicated, right, in terms of interpreting fair use when fair use is changing, right, through transformative fair use cases, such as, like, I just learned something new about fair use transformative cases through the Second Circuit and the Andy Warhol case, right, saying kind of like, you transformed art into art, therefore it's not a fair use. So things are kind of changing often. On the other hand, I don't necessarily think that that's a bad thing. I think that often the change that we've seen in fair use has been helpful change, especially the ones where we came up with the transformative test, right, which wasn't extremely recent. It was from the Supreme Court, I believe, in 1994. But the growth in transformative uses since then has kind of exploded, right? With the Google Books case, kind of allowing us to do more and more in terms of indexing, text mining, data mining. In terms of simplification, I just don't see, the utopia at the end of the rainbow, I guess, that Kevin does with coming up with less rights for, or only rights for creative uses that are commercial. I think we already sort of have that balance with fair use, because that's one of the primary considerations there is the commerciality of the use. But I also think that Creative Commons licenses does a lot of that work, right? So if people create things and they want to put it in the public domain, they can. And they do, right? And so I don't know how we simplify fair use, but I actually think simplification could be bad, especially in fair use, right? Where people were asking for a set rule and Circular 21 said, okay, 10% of the work. And then people took that as like a bright line rule, which was negative, right? Because now we see in HathiTrust, we can use the entire work. And we can use it for data mining and text mining and research purposes. So I guess I'll stop there. I guess in my view, complexity is not necessarily a bad thing, and it can lead to innovation.
Kevin?
Yeah, Sara gave a really good answer. I would suggest, though, that, again, we're sort of trying to nibble around the edges to make things better in a situation that is deteriorating quickly. First of all, I'm not going to argue that the current Congress is the right body to solve this problem. That's probably a different debate than the one that we're having. But I do want to suggest that what I'm proposing is that we shift the default. With millions and millions of people creating every day, our current default is automatic copyright, no moment of decision. So if I don't say, I want to put I know what a Creative Commons license is. That's the first thing I have to say. And then I have to say, I want to apply one. And then I have to figure out which kind of license. What I'm suggesting is that for most purposes, the default would not be copyright. Right now, the default is everything is copyright. Those pictures you took of lovely Charleston, South Carolina on your phone, they're all protected. The notes that I took for this presentation are all protected for 70 years after my death. I don't care. I don't need that protection. Nobody else is going to care. At least At most, what's going to happen is somebody will someday think there's some value to them and be frustrated by the fact that they can't use them because of copyright, or they don't know whether or not they can use them. I'd like to see us, and somebody rightly asks me, who is us? It's a great question. Flip the default so that copyright applies to specific uses and only to other things if somebody makes an affirmative decision to apply it. The default would be closer to a Creative Commons license or no rights reserved or something like that. I'll acknowledge, by the way, that that also runs afoul of our international treaties that we ignored for 100 years of their existence before we decided not only to join them, but to become the strongest advocate for maximum copyright protection. The hypocrisy there is palpable. We would have to either withdraw from those treaties, which are doing far more harm internationally than they are doing good at this point, or we would have to apply the regime that I'm proposing only to our own citizens, because we can impose formalities, and that's what I'm talking about, some kind of moment of decision. We can apply those formalities to our own citizens, just not to the enjoyment of copyright. If anybody really enjoys it, that's the language from the Berne Convention. We are only forbidden to restrict the enjoyment of copyright by citizens of other countries. So there are things we could do.
All right, thanks, Kevin and Sarah. I think we have another question from the remote attendees.
We have a question from Robert. Would be great if someone could comment on the increasing use by the US to insert copyright requirements into trade agreements, like Life Plus 70 in the USMCA and the Australian and South Korean free trade agreements.
Kevin, why don't we start with you on that one? Do you have any comments on that practice?
Well, I think it's indicative of what I just said about the radical change in the United States in the mid-'80s. From having resisted the international copyright treaties for some very specific reasons for 100 years, and then suddenly becoming not only signatories of those treaties, but some of the strongest advocates for strong protection. To be very blunt with you, I think it's evidence of the power of the lobbying efforts of the major content industries. And they want to capture audiences, capture economies, and the U.S. Trade Representative is doing their bidding in many cases in order to do that.
Sarah?
I can't disagree about the fact that the United States sat on the Berne Convention and ignored it, and then finally one day said, oh, now we're going to join it, and everyone should do what we did, right? Not the bare minimum of life of the author plus 50, but everyone should do more.
And in fact, we didn't just ignore it. We were the pirate nation for the beginning of our content industries. So,
and I said so, in my opening statement, to be fair, that I don't disagree that copyright is too long, right? In the Constitution, it says, that we should have exclusive rights for authors to their writings and scientific discoveries for a limited time. Do I believe that author's life plus 70 years is a limited time? I do not. Does the Supreme Court agree that it is? They do. Apparently, anything less than forever is limited in their view. So I cannot stand here or sit here and defend those practices because I don't agree with them either. But what I do think is I can defend or state at least is that the comment that Kevin made earlier about, my notes from this meeting, the pictures of Charleston that we're taking, a lot of that stuff is covered under fair use. A lot of it is, the things that I tweet, the picture that I took of my daughter in her Stranger Things outfit and stuck on Facebook. I mean, a lot of these things get retweeted, reshared under fair use. And I think that blowing up the system is going to do more harm than good. And I really believe that. And I also think internationally it's a problem, but Kevin did note that, right? Because of the Berne Convention, we did agree to it. And now we're bound to give other countries that preference and that national treatment. So it would create problems. But in terms of that dystopian future, I honestly think that's what we would get. I wish it were different, but I honestly think that's what we would get.
All right. Are there any comments or questions from anybody here in the room in Charleston? Yes, at the back. Pull down your mask for just a second. Speak as loud as you can.
Hi, I'm Molly Peter. I'm from Wake Forest University. My question, and this is primarily for Sara, is that given the exemptions and things like Creative Commons that do empower users, we here are more familiar with copyright than the average user, the average everyday creator. So given the argument that the exemptions and the tools we have at our disposal are powerful enough, how do we actually help users understand them? Because they're not all in copyright law. And where does she propose that we sort of direct users to so that they have this full slate of tools for empowerment?
Okay, great. I'm going to try to paraphrase this. And again, give me a thumbs up if you think I got it right. So given that these tools exist, Creative Commons, fair use, the other things that we have available to us to help us use copyrighted material relatively freely, but within the law, but also given the fact that we all in this room and in this discussion are much more informed about these tools and indeed about copyright law generally than the average person. And given that our libraries are serving more the average person than they are the people like us in this room, what can we do? Where should we direct patrons and users to help them make the use of materials that is currently allowed under copyright law? Is that about right? And that question was directed primarily at Sara, but of course we'll give both of you the chance to respond. But let's start with Sara.
Well, hi, Molly, and I wish I were there. And I think that's an excellent question, because the majority of my work, to be honest with you, and probably most every copyright librarian, is education. And it's because, right, we have these tools, but not everyone knows about them. But I would also direct everyone to, I'm sorry, my dog is like at the window, like, let me in. I want to answer this question. I have
a copyright dog too. They're great.
Yeah. So I would direct folks to particular communities who have really engaged in sharing practices, one of which I can think of is the coding community, right? They've even come up with their own standards. They're not necessarily even copyright, Creative Commons licenses, but all different kinds of licenses, and they share pretty freely with each other. Another really wonderful community is jazz music community, right? They share all the time. I mean, it's like that's the default, and that is within the copyright regime. But in terms of my own patrons, what I do personally is I have a lot of library guides. I have a YouTube channel. I have a podcast called Copyright Chat that I encourage folks to engage with. I just try to keep beating the drum, right? To let people know about negotiating their contracts with publishers, about open access opportunities, about open educational resources, about Creative Commons, and all of the different exceptions that are available to them. So there's no easy solution because of the system that we have, but education, education, education.
Good. Sara, Kevin?
Well, I would just remind you all of what I said about excessive complexity. With the number of people who are creating copyrightable works, not copyrightable, I misspoke, copyrighted works, because they have no choice. Copyrighted works. There's just, it's an insurmountable mountain that we're trying to attack with this education. You know, I will point out that both Sara and I have proposed radical revisions to the copyright law. And neither of us is, in fact, arguing in favor of this proposition, to tell you the truth. And it's just really a question of not is the system broken, but how broken is the system, and can we educate our way out of it? And I think history does not provide many examples of where education has been successful in getting out of the kind of hole we've dug for ourselves with wholesale, automatic, and intensely long, immensely long copyright protection.
So I feel like I need to give Sara an opportunity quickly to respond to one thing that Kevin just said. Sara, do you agree with Kevin that you are not arguing in favor of the proposition? I mean, that you are not arguing against the proposition.
I think I am arguing against it, because the one of the key quotes that I gave, which came from Creative Commons themselves, was that Creative Commons will not work without copyright. And Creative Commons to me is one of the strongest tools that we have, right, to combat excessive copyright. So, I mean, surely I'm not standing before you or sitting before you and saying copyright law in the United States is a utopia perfect system, because nothing in law in the United States is perfect, or in law anywhere. I think that's the first thing you learn as a law student. But I am arguing that it does a good job of balancing the rights of authors against the public good. And I think that's what I'm here to argue today. I'm not here to defend copyright law, for every single proposition, but the fact that it has checks and balances, and I think it does.
That's interesting, and I apologize if I misrepresented your position, Sara. I would make two quick points. Creative Commons depends on copyright. Of course it does. You have to have rights in order to license them. But that's kind of like saying the prohibition against murder depends on the fact that people will keep killing one another. There are two sides of a system. The Creative Commons may be the one we approve of, as opposed to the alternative. I'm suggesting that we look for better systems. The other thing I would say is just, you mentioned communities that are, coders. You mentioned several communities, but you said they're relying on fair use. I don't think they are. I think they're just ignoring copyright. Within their own communities, they exchange, they tolerate what would technically be infringement. They're not suing anybody. But those are at least as good evidence for how badly broken the copyright system is, that whole groups of creators get together to at least tacitly agree to ignore it, as it is that fair use is a valuable tool.
All right, Leah, do we have another comment from the remote users?
We do. We have a, a comment from Shawnee. Traditional copyright is creating barriers to access that are holding back knowledge acquisition in our society, and thus holding back our society in terms of advancement in the sciences and medicine and beyond. It is not making money that should incentivize our production in these areas, but rather the desire to explore the extent of our greatest potential and reach that without barriers. It is not money that incentivizes that. It is our most inherent motivation to be better, which is actually stifled by the current predatory market system.
All right, that was a statement rather than a question. Kevin and Sara, do either of you have anything to say in response?
Well, I think it's interesting. He says, I agree. I think it's interesting that Kevin's perspective is that folks are ignoring copyright law, because I think they're operating within the system and just not, you're right, they're not choosing to sue each other, but the system isn't stopping them from doing what they're trying to do. And during the pandemic, a lot of information about research and things it was being shared openly, and kind of the open access movement, right, is pushing us towards more people not ignoring copyright, but working to not keep it from furthering our advancement. Because I agree with you that if we are not, sharing scientific discoveries, medical discoveries, we're only hurting ourselves, right? And I think COVID-19 was a really great example of when the entire world came together, right? And if you wanted to read New York Times about COVID-19 and the pandemic, you could do it without the paywall. And I know Kevin would spin this and say, well, you're agreeing with me. Yeah. But I don't think I am. I think I'm saying that we can balance. And that's what this debate is about. It's about balancing authors' rights and the public good. And we know when we need to do it as a society, and we've shown that in COVID-19.
And
Kevin, anything to add before we close?
Sure. And part of my argument has been that we've been struggling for that balance for 300, 400 years. And it's just getting worse in the current environment. So that's sort of the core of my argument. I would say about open access, yes, I agree with you. It's a great movement to try and make scholarship and scientific knowledge more available. And it is being continually undermined by copyright holders who decline to create the conditions in which scholars can, well, and I shouldn't blame just the copyright holders. Our institutions are guilty of it as much as anybody. But we resist, we use copyright to resist efforts at open access, you know, a year's embargo, 2 years embargo before you can make this knowledge that could save a life available for other people, unless they pay outrageous subscription costs. So open access is a great idea that is being impeded by copyright.
All right. Well, thanks very much for the questions and comments from the audience. We are coming close to the end of our time here, so I think it's time to close the discussion and retake the poll. So I'll ask Leah to, or yep, there we go. I'll ask Leah to put the instructions back up and to reset the poll. Is that?
Do it right here. Sorry.
Oh, yeah, great. While Leah's doing that, I'll just remind everybody, we need you to vote if you voted for the opening poll, and we need you not to vote if you did not vote in the opening poll, because we want to make sure that that we're measuring the impact on those who voted. I can't help, as I watch these results come in, I cannot help thinking about how frustrating it was last night to watch election results coming in. Can you imagine if we could watch election results come in this fast? I would have gotten a much better night's sleep last night. And by the way, while the results are coming in, I'll tell you that in the opening poll, we had 92 votes in favor of the resolution, which represented 81% of respondents, and 21 votes against the resolution, which represented 19%. And it is looking... We'll give it another few seconds here.
Great job, Sara.
It is looking like we can declare Sara the winner. Sara, well done. Kevin, well done. Thanks so much to both of you for your very compelling and thoughtfully prepared comments today. Will everybody please join me in thanking Sara and Kevin?
Thanks so much. This was a lot of fun. And really, Kevin and I do agree more than we disagree.
To which I agree with you, Sara. It was a lot of fun. And thank you for being such a great debate partner. And thanks to the audience for their questions and their attention.
Thanks a lot. This was so much fun. I hope everybody enjoys the rest of the conference.
Thanks, everyone. Thanks for being here today.